where Nathan joins us from outside the Supreme Court, where they just take us through this entire ruling and tell us the people who petitioned the Supreme Court.
Garga, instead of me telling, actually one of the lawyers who argued for one of the Telgi's associates, Mr. Manoj Goel, is here. He will exactly tell what exactly happened. Sir, what is this case about? Can you tell the...
See, the whole issue before the Supreme Court was about the constitutionality of these narco, brain mapping and other tests which are conducted against the wish of the accused persons. And the Constitution doesn't permit such kind of test to be done, because Constitution allows an accused person's right to remain silent. And that is what has been upheld by the Supreme Court today in a very historic judgment. And this is a judgment actually not only a big boost and a big step forward for the human rights jurisprudence in the country, but in fact for the entire world, because this is the first judgment, first authoritative judgment in the world, in any jurisprudence in the world, where this has been so categorically held to be unconstitutional.
But what happens to the voluntary? Court only said compulsory should not be done. What happens to voluntary?
In respect of persons, accused persons who want to undergo these tests on their own volition, court has held that yes, they can do it, but that can be used only as a tool in investigation, and anything obtained by virtue of these tests would not be evidence admissible in the trial.
So what happened in 2611, that Kasab's conviction? Is it based on the narco-analysis or separately?
No. On the contrary, Kasab's conviction, as we have heard from the media, we haven't seen the judgment, so I can't really comment on that. But whatever we have seen from the media is based on circumstantial evidence, and therefore that will not be affected by the outcome of this.
So whatever the conviction which has been given or done based on this narco-analysis, what will happen to these convictions?
Those convictions, if they are primarily based on this evidence which has been obtained by virtue of these tests, then the test having been declared unconstitutional, and therefore the evidence would also become unconstitutional, and such convictions are bound to go.
Secondly, he said the investigative agency should follow the NHRC guidelines. Can you just throw some light on what are the guidelines?
No, the guidelines are only facilitative in the sense that you have to conduct investigation in keeping with the fundamental rights jurisprudence, and therefore you cannot really compel. The compulsive element has to go in whatever way. Third degree, of course, is the worst way, but then this is worse even than the third degree, because you take away the volition of the person, his capacity to decide for himself whether he wants to make a statement or not. That itself is taken away.
But investigative agencies say that they don't do it compulsorily, only voluntary they take.
What?
No, voluntary.
No. You know what? The procedure is not like that. They ask the accused person, they say no, they go to the lower court, they take permission from the lower court for these tests. And then once the court grants permission, then against the wish of the accused persons, these tests are conducted.
Is it not a setback? You see, terrorism everywhere, there are a lot of efforts being put in by the government. Don't you think it's a setback to the investigative agencies?
Two things. First, it's not a setback, because earlier also there have been investigations. You have investigations world over, not just in India, of terrorist offences, and terrorists are convicted, tried. There's no setback really. But if the state wants to use it as a scapegoat for saying that, look, there's a setback to us, I think that's a very poor way of overcoming their own lapses. Thirdly, if the executive is so sanguine that they so badly need this test, what they should have done is they should have brought a bill in the parliament. Parliament should have discussed that. It should have been discussed outside the parliament. Let the whole country discuss all these aspects, and then they should have made a law. And perhaps then it would have been tested. But instead of doing that, they wanted the Supreme Court to approve this policy, which the Supreme Court has, in great respect, very rightly put a very firm no.
But still government can bring in a law.
Not now. After having been held unconstitutional, there is no way that they can bring law. But I'm saying this, they could have done that earlier, but not now, obviously.
Tuba.com